Hello. In this recording from our Justia webinar, Fiduciary Fundamentals, Managing Client Funds and Avoiding Common Missteps, Tracy L. Kepler explains the financial responsibilities of lawyers under the ABA Model Rules of Professional Conduct, focusing on ethical and billing practices, proper management of client funds, and procedures for returning property upon termination of representation. Remember, if you'd like to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Thanks so much, Nina. And I'm going to go ahead and share my screen. There we are. Thanks so much to everybody for joining me today. Good afternoon, good morning, good evening, depending on where you are. And I love that Justia scheduled this webinar on today, right? Tax Day, April 15th. And so we're talking all about fiduciary fundamentals. We're gonna managing client funds, avoiding common missteps. Hopefully at the end of today's session, we will get to all the questions, but if not, certainly feel free to reach out to me directly. This is my direct line, my work cell phone number, and my email. Always happy to answer questions as they come up today and then later. But so you know where we're headed for the next hour, I wanted to give you a roadmap or at least some objectives that I'm going to try and accomplish throughout today's webinar. We're going to kind of run the gamut from, legal ethics to best practice scenarios. We're going to talk about fee agreements and responsible billing practices. We're going to talk about what is a reasonable fee under the Model Rule 1.5a. And I should say here that throughout today's presentation, I will be referring to the Model Rules of Professional Conduct because it is a national audience, but you do want to check your state jurisdiction's rules for the specific language because there may be differences. We're going to talk about some client fund management, right? How to keep client funds separate and the requirements under 1.15a. Shutting it down, right? When the representation is over or you withdraw, what are your financial obligations? How do you return the funds? And then finally, what I want to do, and pretty much with each section, I want to give you some practical takeaways. I want to give you some things that you can put into place in your practice setting, no matter if you're a solo practitioner, small firm, boutique, or larger firm, things that will work and things that will help you not run afoul of some of these mistakes and some of these violations that we see routinely when we're dealing with financial issues. So where do I want to start? And I start here. And I'll be honest with you. I also teach professional responsibility and legal ethics at Georgetown, at American University, Washington College of Law, and at Loyola here in Chicago. And a lot of times my students will say to me, Professor Kepler, why are we even talking about this? I'm going to big law or I'm going into a different kind of practice where I'm not going to handle client funds. I'm never going to touch the money. Somebody else is going to be doing that for me, or that's not the kind of work I'm going to do. So why do I even need to talk about this? And I like to say, and I'll say it here to you as well. Why do we need to talk about this? Well, the reasonableness of fee issues, fee agreements, misappropriation, conversion, commingling, all of those kinds of things are not just a solo practice problem, right? We see all kinds of cases involving all of these rules and all of these concepts, from the solo practitioner on up to Am Law 100. In big law, just of late, we have seen cases where attorneys have been, stealing client funds. There was one just late where there was a 12-year criminal sentence for one attorney. Another case in New York where it was a law firm partner was sentenced to 5 years in prison for conspiring to defraud and running, funds through his attorney client, his IOLTA account. Another incident of late where a corporate lawyer basically admitted to stealing $10 million in client funds. So not only was it a violation of the rules of professional conduct, but it was a criminal matter as well. In addition, there are all kinds of practice settings, right? And while you may not be handling the day-to-day deposits and disbursements and withdrawals and wire transfers, many big firm lawyers still lose their license for a violation of 1.15A. The other thing to remember is that sometimes, attorneys are dealing with estate assets, wills, estates, and trust, probate assets. And so, it might be in that circumstance where this segregation or separateness of client and third party funds, you run afoul of the rules there. In addition, think about all the other people who touch client funds. Your accountant, your bookkeeper, your paralegal, your, administrative assistant, your whomever, right? Who other staff members in your firm who not only have access to, but may be responsible for client funds. And so you have to think about every single person who is touching that, which plays very well or dovetails very nicely into your responsibilities as a supervisor of non-lawyer assistants. What I'm talking about there is Rule 5.3A, your duty to supervise, your duty to make sure that reasonable efforts are in place for everybody in the firm so that everybody understands what the rules of professional conduct are. And quite frankly, that you can be on the hook for one of these non-lawyer assistants' mistakes. Hopefully it's a mistake or intentional error with regard to client funds. 8.4C, you have to think about as well. It's not just reasonableness of fees under 1.5 and all of the subsections or 1.15. It's, professional misconduct involving fraud, dishonesty, deceit, or misrepresentation. So that's the why. You need to know these situations because it has much broader application than just who touches the money. So jumping into things, where are we going to start with financial responsibility? I think a good place is really with the reasonableness of fees. You have the Rule 1.5A in front of you. And again, it's my crib notes here, right? It's not the actual rule, but it's a great jumping off and discussion place to start the discussion. Remember, this is a shopping list, right? Unfortunately for us, the rule doesn't say this is or this is not reasonable. What it does is it gives us a multitude of factors to go through to try to make this determination. Luckily, we have the comments to the rule that are instructive as well. And I think it's important to note that comment 1 says it right out there at the very beginning, right? These factors are not exclusive, nor will each factor be relevant in each instance, right? When the court is looking at what is going to be a reasonable fee, it may ignore certain of these 8 factors if they're not relevant, and all of the factors don't have to receive equal weight. What I am not talking about here is statutory fees or fee shifting statutes. Decisions on those types of cases are considered separately. It's a different context. They are distinguished. I'm just talking about your regular old, fee that you're charging. What are the factors that we consider? And the 8 of them are here, right? How much time and work is going to be involved? What are you putting into it? How complex is it, right? What's the novelty and the difficulty and the skill required for you to perform these legal services? The second one I like to call the opportunity cost. It is the likelihood that you're not going to be able to take other business because you're representing this client. You're not going to be able to take on other cases where you may be bringing in fees. So that's a factor to consider. The fee customarily charged in the jurisdiction. It can be, $100 for, maybe a small rural community and up to $1,500 in Manhattan, for example. What is at issue is another thing to consider. What is the dollar amount involved? What is being sought? What are the objectives from a financial standpoint? and what kind of results will I be getting? What will be the outcome or the likely outcome or the hopeful outcome? Um, Again, time limitations, not only for this client, but for the circumstances. Am I limiting my time? How much is it going to take? What my relationship is with the client, right? Are they a long-standing client? Is it somebody who's just walked through the door? What is the nature of my relationship with that client? In addition, I think some of this comes to, the sophistication of the client, the legal sophistication of the client. Certainly who you are, right? Your background, your experience, your reputation, your ability, your specialization, your expertise is something that comes into this determination. And then lastly, whether the fee is going to be a fixed fee, a flat fee, or it's going to be something on a contingency fee basis. These are the 8 factors that you look to when making the determination as to whether or not your fee is reasonable. So we've gone through all those factors. We know what we're supposed to look for, but can you give me any explanation or any understanding of what would be unreasonable? Is there any case law out there or, disciplinary cases that would talk about this? And quite frankly, there are. There are tons. And there are several categories that I like to talk about where we're discussing the unreasonableness of the fees. And the first one seems obvious, right? Bill padding or double billing, where you are billing for the same work twice. I know I had an instance back in the day where bar counsel were submitting, and I mean bar counsel like somebody who's been appointed and is getting a statutory rate or a local rate for the fees for the services, would come in and would be going between different courtrooms in a juvenile setting, and in their fee petition you would see them bill for 28 hours in a day. We know that's not possible. Or billing time for time spent on each fee petition for each hour spent in the courtroom. So 6 hours, 6 hours, 6 hours. Okay, it's just not possible. Billing, adding to the bills. Billing also, we have found there are some cases that say if you bill in quarter-hour increments, that is likely to result in an unreasonable fee decision. Fees for doing nothing or for doing very little. You take a big retainer, you take and you don't do anything, right? You do nothing at all, or you do very minimal work that wouldn't justify, the retainer that you've taken in. Charging fees and not doing the work, or doing very little and then doing it badly. Certainly, when you're looking at the reasonableness of a fee, what is ultimately at issue is the reasonable value of the services that are being rendered and received by the client. And if those two, don't come to some sort of equilibrium, you might have a problem. Doing way too much, excessive lawyering, as I call it. There's a great case out of South Dakota, in re Dorothy. It's an oldie but a goodie, where the lawyer tried to charge almost $60,000 and did charge more than $47,000 for an incredibly uncomplicated child custody and support representation. Apparently, this attorney did tons of excessive briefing that was actually of little or no value in the case. That's the kind of thing I'm talking about. Doing remedial work. What do I mean by that? I mean, look, you as a lawyer are expected to provide competent and diligent representation. And you're not supposed to be charging your clients for time that is necessitated to gain expertise, right? Obviously, you can talk about the client. You can always engage in self-study, but you have to discuss that with the client first. You can't, your own inexperience, you can't bill for that. Another one, work that benefits the lawyer and not the client. What does that look like? Billing time that you spend responding to your own disciplinary grievance, or billing time that you spend for completing timesheets, right? That's work that benefits you and not so much the clients. Another place where we see unreasonable billing is too many lawyers billing, right? Where there's participation by too many lawyers in the firm. It's sort of that same sort of excessive lawyering or over lawyering that I was talking about that can result in an unreasonable fee. There's another case, and it was an Oklahoma case from 2001, Heavener versus Myers. And I love this because it just is over the top egregious. There were 49 invoice entries for in quotes, discussion with co-counsel. That they said, the court said that was a prime example of what constitutes an unreasonable fee. And then the last one, charging lawyer rates for non-lawyer work. A lawyer is not allowed to bill non-lawyer services at lawyer rates, no matter who performs them. And the type of services that are contemplated in this reasonableness decision are tasks really that are considered administerial or clerical, which you can't bill at lawyer rates, kind of even if the lawyer's performing them. Things like organizing, distributing, copying, scheduling, logistical planner, administrative and ministerial things. So we've talked about what the reasonableness of fees looks like and what an unreasonable fee is. I really want to think about some alternative fee structures and some ideas around success fees, what they are, how you can use them, the risks, the benefits, and some practical takeaways. The concept of a success fee is really rooted in the idea that a lawyer's compensation is contingent on achieving a favorable result for the client. And originally, and we all are familiar with contingency fees, right? That's how it started. That's a staple, of certain areas of legal practice. And this is really emerging from that. We're in an ever-changing environment with regard to fees, coming up with new structures. And certainly, using a success fee is one of those innovative billing structures that lawyers are currently contemplating. Certainly, this is something that happens at the inception of the matter, and you have an opportunity to, achieve or earn an additional fee for a successful outcome. I think the other thing to remember with the success fees are that they are defined at the outset of the representation, right? Whether it's going to be a quick settlement, a verdict, an arbitration award, whatever it is, within a specific dollar range, time frame, whatever. This is something that you're going to talk about with the client at the very outset of the representation. I also think success fees have tons of benefits, right? It's a shared risk, right? Spread the risk around. There's an accountability here for both the lawyers and the clients with regard to the legal matter, and it's designed to pass on some of the risk to the attorney. That's one benefit. Predictability. Clients can actually more accurately budget and plan for legal costs, and lawyers are encouraged to provide legal services more efficiently and focus on value-driven client services. Another benefit is cost cutting and certainly cost containment. Law firms can increase profits and pursue ways to deliver more value or motivate extra effort by staff. And then the last benefit, as I see it, is really a relationship building one. I think success fees require communication. They require a close working relationship with that client. At the beginning of the representation, they reinforce a sort of a sense of shared commitment, if you will, towards the client's objectives and goals, and in some respects, a shared financial risk. But that's not to say that there aren't downsides as well. And there are certain risks to success fees. Certainly, when we talk about costs, they can be costly to the client if the success criteria are met, right? Or on the other side, detrimental to the law firm if they're not met. There are also quite a few ethical pitfalls when implementing a success fee. And we'll talk about those, where we find those pitfalls. I think, while the model rules of professional conduct don't specifically prohibit success fees, they really do set clear guidelines regarding fees and conflicts of interest that you have to assess when making the determination as to whether or not you're going to engage in this type of fee agreement. The first rule we talked about, the 1.5A, the reasonableness, going through those 8 factors, certainly that is one component. The second one, and it is something that, was at issue when contingency fees were first implemented, because those weren't allowed for the same reason that I'm going to talk about, where success fees may be problematic. What is that? It's the conflict of interest. Either a material limitation under 1.7A2, that prohibits a lawyer from representing a client where there's a significant risk that your representation may be materially limited. By your own interests. In addition, there's a comment 10 to that rule, that says a lawyer's own interest should not be permitted to have an adverse effect on representation of a client. Again, these are things that can be waived. These are conversations that you're having with the client. You are having an informed consent discussion with the client, right? Talking about the risks, the benefits, the pros, the cons, the alternatives, because, you want to make sure that that client understands what they're getting into, and that the lawyer's financial incentives may not always correlate or align with their own. The other conflict of interest rule that is at issue when you start talking about success fees is 1.8I. And this is a rule that's basically says attorneys typically are prohibited from sharing in a client's financial success. And it talks about a lawyer may not acquire a proprietary interest in the cause of action or subject matter of the litigation that the lawyer is conducting for a client. Again, a difficult place, but one that can be overcome by conversation, communication. Think Rule 1.4, informed consent, and waivers. The last rules that I think you have to think about with your ethical implications and regard to success fees are really 1.1 and 1.3, the competence and the diligence. Taking care of all of those issues, making sure that this is the right case at the right time for the right amount of money for the right client, and that you are able to undertake the work and do it effectively so that you can comply with those obligations. Just a few best practices when you're thinking about getting into this type of fee agreement with your client. I think at the risk of restating the obvious, implementation of a success fee has to work for both the client and the attorney to be successful. So you have to think about, is my firm, am I as a solo practitioner ready for this type of fee agreement? Can we what are our current billing practices? What is our financial situation? What is our adaptability to bringing in or to engaging in a new fee structure? What internal systems do we have now to track billing? All of those kinds of firm operational, administrative types of concerns that you want to think of before even getting into considering whether or not we're going to have this type of fee agreement. Certainly, what I talked about when you're talking about 1.1 and 1.3, identifying those cases or those legal services that are actually suitable for a success fee. I mean, not all legal services provided by a firm are going to be ideal candidates for this type of billing structure. I think complex litigation, cases with uncertain durations, or transactional work might be better suited for success fee models, where, the key really here is to match the fee arrangement with the nature of the legal work and considering factors that we looked at in the success fee: complexity, duration, client expectations, all of those kinds of things. Knowledge, you've got to do some education of yourself, right? Understanding what success fees are, how they work, the benefits, the risks, the types of matters. Understanding what your own business is from a law practice management. Is this going to help or hinder the firm from a financial perspective? Monitoring and evaluating, is this working? What you're going to build into your engagement agreement, right? You've got to decide upon and implement new engagement letters or attorney-client retainer agreements. How is this going to look? What language are we going to use? And I think the first step really is to work with the client to determine whether a success fee is effective for this particular matter. It's a great opportunity for communication, and I think success fees work best sometimes when the client is a sophisticated consumer of legal services and there's a pre-existing attorney-client or other relationship that has allowed the parties to develop a trust in one another. I think trust is at the cornerstone of this type of relationship. The second step, after you've made this decision, is actually to put pen to paper or fingers to the laptop or to the computer and draft the fee agreement. In some respects, in collaboration with the client. You're going to address the client's needs and goals. You're going to define the scope of representation, the details of the fee, and how it is going to be determined, and clearly and accurately defining when the success is achieved, right? And obviously, it goes without saying that the total fee has to be unreasonable. Now, there's all kinds of templates for success fees. I'm happy to provide some to you offline if you're interested in this and how you go forward with this. Please feel free to reach out to me. I said monitor and evaluate. Is this working? You're going to implement this, but is this a winning strategy for me and or my firm? An ongoing evaluation, monitoring, so you can cut it off if it's not, change it if you have to, or continue to grow in this line. And then clearly, right, adjusting your strategy, adjusting your fee agreements based on feedback and the results that you're achieving. I think flexibility and adaptability is going to be crucial when using these types of fees. Another issue when we get into reasonableness of fees and the types of fees, or maybe I should say the types of payment that you are accepting. I think a big issue has been cryptocurrency. And this has been an issue way back, since 2017, when Nebraska was the first and only state that came out with an ethics opinion on an attorney's ability to accept cryptocurrency as a form of payment. Now, many other state bar associations have actually grappled with and issued ethics opinions on this topic. So there's a lot out there depending on what state you're in. But I think the general consensus is that lawyers can accept payments in digital currency, but they have to be immediately converted into US dollars. The other sort of consistent issue or statement with regard to crypto is that any refund of monies, something that's either disputed fees at the end or fees that have been unearned and that you need to return because you've withdrawn or terminated the representation, have to be refunded in US dollars and not the digital currency. I think, there are a lot of benefits, right? And we talked about the reasonableness of the fee. Safeguarding is another issue. But in some respects, sometimes accepting crypto presents more problems, more issues, more unknowables, more risk than the regular attorney is willing to accept. You have to think about so many issues. How are we going to handle the transaction fees? Who is going to pay those costs? What exchange are we going to use for this purpose? Who, the lawyer or the client, is going to pay the cost for the conversion from crypto to US dollars? What if the client says, I want you to hold my advance fee payments in Bitcoin instead of converting it to US currency? Can you do that? What are the risks inherent in that? What if Bitcoin, goes up or goes down in value while you're holding on to these client funds? Who gets the windfall, or who has to pay? The lawyer or the client? Like I said, who bears the risk if the Bitcoin drops in value? Certainly, and there are, these issues, things that you need to be thinking of, and also some practical steps if you've decided, yes, in fact, I am going to go ahead and accept cryptocurrency. The first thing I think goes without saying before you even get into this line of accepting fees is some education and training. You have to have an understanding of the fundamentals of cryptocurrency and blockchain technology. 1 point comment 8 to 1.1 requires that lawyers, are familiar, or keep abreast of changing technologies. That's part of your requirements. But certainly you need to be, hip to it, because one, there's frequent changes in cryptocurrency, regulations, new policies, procedures, statutes, things coming out, and you need to keep on top of that so that you can monitor it accurately. The other thing is, if you're going to do it, you need to have an internal policies, comprehensive policies for accepting cryptocurrency, setting guidelines for what you're going to accept, how the payments are going to be processed, how potential issues such as price volatility are going to be handled, who's going to handle the cost, all of these kinds of things. This sort of policy has to include client notification, choosing a reputable exchange, and accurate record keeping, going hand in hand with the client agreements, making sure that all the T's and all the T's are crossed and I's are dotted, making sure that, you clearly outline the terms of the payments in your fee agreements, specifying how it's going to be calculated, knowing the value of the cryptocurrency, how it's going to be determined, the timing, all of these kinds of things, and even maybe an admonishment to your client to consult with tax counsel regarding, this type of situation. Another concern, and I don't want to spend a lot of time on this, is the security and secure transactions with regards to cryptocurrency. As I mentioned it briefly, but using a reputable cryptocurrency exchange and wallet for these types of transactions. And then the last one, and the one that sometimes gets forgotten, is the tax consequences, right? Or the tax compliance. Attorneys really do need to stay informed about the tax implications of accepting cryptocurrency. If you didn't know, the IRS treats crypto as property, meaning that every transaction can have potential tax consequences. And you should ensure that not only you, but your clients, understand this tax reporting requirement should you be using this technology. Fee agreements. Why do you have a fee agreement? Well, it just makes sense, right? When we talk about expectations and boundaries with our clients, it is critical to have something. I mean, it's not required, right? Unless it's a contingency fee agreement or some other agreements, depending on the state you're in. But I think you can address so many issues up front if you just have a writing, right? By memorializing all the terms discussed during the initial consultation and clarifying all the details of your payment terms, your protocol and your relationship with the client is much better. There is less misunderstanding. There is less sticker shock at the end of the representation. Again, saying what kind of payment you're going to accept, the fee structure, when I'm going to bill, who's responsible for costs, what happens if there's a delinquent payment. Setting out all of this at the very start only enhances the relationship and avoids a problem on down the line. Now, I talk about this as at the start. I don't mean to say by saying that it's only at the start. I really do think for a successful relationship, and nobody likes to talk about the money, let's be honest, right? You don't want to talk about it. You want to talk about it once and get it over with. But I think engaging in ongoing discussions with the client regarding fees will really help you in the long run. It doesn't stop after the first meeting. I think a lot of times in most cases, your representation of the client may take weeks, if not months, and maybe sometimes even years. And so a consistent dialogue about what time you're spending, what the bill looks like, avoiding this sticker shock, maybe sending with more frequency will help you collect your fee, and there won't be as many disputes at the end once the representation has concluded. In addition, a whole host of other information that you want to include in your writing, some great language, some great ideas in comments 4, 7, and 9 to Rule 1.5 about what you want to have in there. Some terms. So again, expectations and boundaries. You and your client are always on the same page with regard to the money. What kind of information is this? As I said, 1.5b tells us what needs to be in there. The scope of the representation, what you're going to do and what you're not going to do. And think about Model Rule 1.2a that talks about objectives and means. Certainly the basis or the rate of the fee. What are you charging? How much per hour? How much in a fixed or flat fee? Is it a contingency fee? What it is, and how often you are going to bill and what that looks like. Who's responsible for the expenses or the costs? Putting that into your fee agreement. Again, preferably in writing. I would say from a risk management standpoint in my line of work, always in writing. You want to have that document, right? You want to have it in, and even having the client countersign that agreement would be helpful. Some states require that, not all, but I think that's preferable. The rule says that this discussion or this agreement has to be put into place before or within a reasonable amount of time after commencing the representation, right? You're going to have the initial discussion. You're going to have the client sign this attorney-client retainer agreement, fee agreement, whatever you want to call it. It doesn't happen 3 months down the line after you've already started the work, after you're already, keeping track of your billing records. No, close to or at the time of when it starts. We have seen some cases where there was no fee agreements and then there was the dispute, or the attorney said, oh yeah, and by the way, I know I finished the work. Here's what we agreed to on the fee, orally when we just had a handshake at the very beginning. No, before or within a reasonable amount of time after the representation starts. And can you just change the terms of the agreement willy-nilly any old time you want? No. If you're going to modify the terms, you've got to communicate those changes to the client, and then you want to file a supplement or an amended fee agreement reflecting and memorializing those changes. Another type of fee. We talked about it a little bit, the contingency fee. That's Rule 1.5c. Again, historically, they were unethical because of the conflict of interest. You as the attorney may have an interest, a financial interest, in pushing it to the nth degree when the client really, wants to dismiss or doesn't want to go any further. That tension there, that butting of the heads. But I think, the consensus, Standing Committee on Ethics and Professional Responsibility, as well as legal scholars, said, look, there are so many cases, an access to justice issue. There are so many cases where a client does not have the financial wherewithal to bring this type of case or to bear the cost of the expenses up front, that we're going to take this contingency fee approach and go forward in that way so that client can have the representation and also, that they don't bear all the risk. Certainly, what do you have to have in that must be in writing? Pursuant to the model rules, a contingency fee agreement must be in writing. You have to say what percentage of the fee you're getting, 30% before trial, 40% if we go to trial, whatever the breakdown is, 33 and a third, whatever the breakdown is, having that as one of the components of your agreements. How expenses are going to be handled, who's going to pay for those on the back end or the front end. You have to provide the client with an accounting and certainly with a disbursement statement, but that comes later. What you are going to do, the scope of your representation, and I throw in quantum merit there. Am I allowed, let's say the client terminates my representation and goes someplace else? Am I allowed to get some of the time that I put in, the value of my services from that if there is an ultimate settlement? Can I put an attorney's lien on that ultimate settlement? Do I get to keep some of my hard labor, right? The money that I have earned? That is it's a tough question for our national audience. It really is on a state by state basis, recognizing that you can't, interfere or harm the client's interest if the litigation is ongoing. But certainly some quantum merit and keeping a record of the time that you're putting in for that purpose, should the representation be terminated, is important. The other provisions of 1.5, 1.5D, you are not allowed to charge a contingency fee in a domestic relations matter or a criminal matter. I think, it goes without saying that why that is. Certainly from a domestic relations matter, when we think about the conflict there, we don't want to prevent the lawyer from discouraging reconciliations should the parties decide they don't want to dissolve their union, child support issues, and with regard to criminal for the same types of reasons. 1.5E talks about the division of fees when you're doing a referral relationship, or when you're partnering, collaborating with attorneys who are not in the same firm. Again, the rules talks about that the fee needs to be proportional to the work that is being done by each attorney. Each attorney has to have joint, responsibility or assumption of responsibility for the risk. There has to be a writing, right? The client has to be aware. There has to be discussion, informed consent with the client to this referral relationship. And as we have been talking about, sort of to come full circle on 1.5A, the ultimate fee, split between the parties, how it's being apportioned, has to be reasonable. Okay, 1.5, let's talk about some risk control measures so that you don't have these fee disputes. Some things that I will say, I talked about it. Expectations and boundaries. Set them during the intake process. Talk about, this is how often I will bill you. This is what it will look like. You'll receive an invoice. These are the deadlines for payment. This is what will happen if you don't pay, right? And in some respects, you really have to do an assessment into your client. Do they have the ability to pay this bill to begin with? If you do your due diligence in this regard, you will stave off a lot of those fee collection issues on the back end. If your client doesn't have the wherewithal to pay for your legal services, this is not going to be good for you. Some things that you can do, there's all kinds of websites. You can, be a cyber sleuth and go to the recorder or to the Secretary of State, Federal Trade Commission, federal and local dockets, see what suits they have out there. Debtor locator, asset reports, identity verification, all of those are open to you. While credit checks are not appropriate in every circumstance, they can be a practical approach where you have a client whose matter is probably going to incur significant fees. Certainly, you have to obtain the consent of the client before doing so, but it may be a tool in your arsenal. We talked about getting it in writing and then asking for some money up front can help as well. Technology, efficiency through technology is a wonderful thing. I think a lot of, and most of us, have a law practice management software to handle our accounting, to handle our bookkeeping. Certainly, it is going to minimize errors when you're sending those invoices. It is efficient. It is quick. It is real time. So you always know what's out, what's accounts payable, accounts receivable, outstanding matters. And you can also see the real time actually alerts you to any emerging billing issues or problems that you might be having with the client before, the representation has terminated. I think also important is to remember some good billing etiquettes. Having your bills clearly and accurately describing the work that you're doing. Again, this will depend on the sophistication of your client, the language that you're using to articulate the services you're providing. A lot of times, you send one lump sum. It may be hard for that client to pay $20,000 all at once. So maybe monthly billing to enable that client to pay in smaller increments. Something that attorneys often forget when they're sending the invoice, something that is just nice professionalism. In addition, with that invoice or bill you're sending them a status update, right? Even if there are no developments, right? Still waiting for the judge to render their decision, still waiting for the order, some sort of, so that the client knows you haven't forgotten about them and you're just sending a bill. The next one is key. There is nothing worse than sending a bill to a client with an error and having that client pointed out to you. Talk about lack of trust and, trust around the accuracy of your bills. Review them, right? A once over, a twice over, maybe even get somebody else involved, a 3-tiered bill review process. You want to catch the error or the overcharges and make revisions or give something for free on your end. Like I said, marking some time entries as non-billable where it's appropriate. That always clients always love that. And as I said earlier, this is an ongoing discussion. This is not just at the end. Because when there's a settlement that comes in and you tell the client it's $100,000, how much do you think the client thinks they're going to get? $100,000. And then when you present them with that disbursement statement, that's the sticker shock. Like, wait, what happened? Where's all my money? Talking about it throughout and making sure that they understand at the outset what it is. So now you've done all that, right? You did as I said, you took these practical steps, but the client's still not paying. Or there's an overdue bill, right? All your efforts have not resulted in prompt payment by the clients. What am I supposed to do? I think the first thing you do is call the client. Look, they may have moved. They may have changed emails. They may not be even getting your bills. It may just be an oversight, right? You calling that client is much better than your accounting department or your bookkeeper or whoever sends your invoices, sending them, with a big red stamp, past due or overdue bill. Having a conversation may get you the money that you're looking for better than just sending, delinquent bill notices. I think key into this conversation is preparation. You need, just as you would rehearse an opening or a closing, practicing what you want to say and how you want to say it is key. I think for a lot of us, discussing money is uncomfortable. It's not something that we want to do. It's unsettling. If you don't have a lot of experience, you want to get good with it so you don't feel the ire coming up your neck. Making sure that your tone, you remain professional during the discussion. And then, give options, right? Maybe, if the client says the check is in the mail, you're like, okay, great, it's coming, and then if it doesn't come, you reach out again. Maybe you set up a payment plan, memorialize the discussion, whatever it is. Having the discussion is going to get you things more times than not, and it will forestall having to go to a collection suit. Consider a compromise, right? Maybe there's a reduction in fees. Maybe you can give a credit towards future legal fees. If they can't, maybe there's some way that you can come to an agreement on what is owed so that while, not totally happy, each party can be satisfied. And I think here's the problem when the client becomes evasive, when they don't respond to your emails or calls or texts, they haven't sent payment. That's when you really have to decide what your next step is going to be. Is that next step going to be, I actually file suit against the client, which leads me to my next topic, which are the risks of a collection action. You have to think about before you even get into it, think about the likelihood of success. versus the investment of your resources into this collection suit? Is it worth it to you? Also think about, is this client judgment proof? Am I going to go through all of this and there's no way I'm going to get the money, right? I'm never going to get it in bankruptcy. I'm never going to be able to secure a lien. I'm never going to get this money anyway. So I'm going to go through all of this and it's not going to be worth it in the end. The other thing I think you need to think about is, more often than not, and it's almost up to 50%, when you file that suit for collection of fees or that collection action, what do you think comes next? Yes, a counterclaim for malpractice. It's almost 50% of the time. That is what's going to happen when you file this suit. So before you even get there, you need to make sure that your file is in order, that you actually earned the fees, that you're saying are owed, that they were reasonable, all the kinds of things that we've been talking about. In addition to that, malpractice claim typically comes a disciplinary grievance, and there's all kinds of other issues or other adverse consequences that may result from your filing of this collection action. Reputation, costs, what your premiums are, judgments, taxes, all those kinds of things. Now, here's the odds. I said almost 50%, 42 to 47% chance that your client is going to file a counterclaim for malpractice. If it's in, if you practice in the area of family law or real estate, the odds, go up even above 50% that is going to be filed. So some questions that you want to ask yourself when you're making this determination as to whether or not you're going to file. Okay. Like I said, how well is your performance, the legal services that you provided, going to stand up to this malpractice counterclaim, right? What are the odds of me winning? Did I, comply with the standard of care? Think about that. And if yes, absolutely, let's go forward. Is it still worth pursuing? Then that's when you got to look at, are all those fees? Did I comply with those 8 factors under 1.5A? Will my fee be determined to be reasonable? Certainly, you're not going to be able to recover excess fees. So are the fees that I've charged, the fees that I'm saying are outstanding, are they reasonable? And if it's still worth it, the next question to ask is, what is my time worth? Deduct those legal fees from the value of your time. What is going to be consumed by pursuing this collection action and then also defending the legal malpractice claim? Think about your insurance coverage. Maybe your policy is not going to cover the counterclaim. And then just think you're not going to have any coverage for the expenses in prosecuting the fee. You still want to go forward. Think about, am I seeking to recover just the fees for legal services? Or am I also thinking about expenses and the tax implications? And then some last things that you want to think about. It's the immeasurable, right? I can't put this one into dollar amounts. Deducting the value or the damage to public relations and goodwill. What is that worth? What is my reputation, my firm's reputation worth? It's, it's an immeasurable. And then also thinking about what portion of that fee is going to be uncollectible, for that judgment-proof client. If this person couldn't pay because they don't have the financial wherewithal, going through this whole process is not going to be worth it. And after you answer all those 6 questions, right, and if the adjusted balance that you come down to is still large enough for you to file suit, then okay, go ahead. Discuss it with a collection attorney, do what needs to be done. But also, think about that this may be a good time to think about my billing strategies, my due diligence of clients at the intake level, and my collection procedures. Good time for review and revision. With the last few minutes that I have, I want to talk a little bit about the safekeeping of property. This is the conversion, the misappropriation, the commingling, which is all part of Rule 1.15A. Now, these rules and all of the subsections vary dramatically across the jurisdictions, so I can't be more clear here. that you really do want to look at your state rule, particularly with regard to the record keeping, the disbursements, the reconciliation. Take a look at what your state's rule is. We're going to talk about some 30,000-foot view concepts here. And the main concept, and you have the model rule in front of you. Look, you have to hold property of clients or third parties in your possession in connection with the representation separate from your own. There are three characteristics: separate, accountable, and identifiable, right? Why separate? Well, if my client or a third party's funds is mixed or commingled with my own, and the IRS comes in and puts a levy on that account, how will my client ever get his, her, their fees? What if I get sick? What if I can't manage my practice and everything is commingled into one account? Accountable. Clients can ask for an accounting. I have to keep accounting. I have to keep books. I need to keep things separate. So there's deposits, disbursements, wire transfers, costs, expenses, what remains. And certainly identifiable, making sure that that account is identified as a client trust funds account, a trust account, or an IOLTA account, interest on lawyer's trust account. What is nowhere in the rule itself, 1.15a, do you see these two words, conversion or misappropriation? What does it mean? Well, it means the unauthorized use of entrusted funds, including not only stealing, but also the unauthorized temporary use for the lawyer's own purpose, whether or not the lawyer derives any personal gain or benefit. Long description, but I think very apt, right? It doesn't mean it can be temporary use. It can be for my own purpose, whether I get a gain, a benefit out of it, but it's entrusted funds that I have stolen or I have taken temporarily. What is commingling? We actually do see that word in the comments to the rule. It's mixing lawyers' funds, business or personal or operating, with entrusted funds. Is it an issue? Well, the comments tell us that we're allowed to have a little bit, nominal funds in our trust account to cover, bank fees, checks, wire transfers, but you can't keep tons of money in there, right? It has to be nominal. Some general duties that we see under this rule. I talked about the duty to notify promptly when client or third-party funds come in, notifying the client of those receipts in a very time-sensitive manner, keeping them separate, record keeping, accounting to the client should they request one, delivering those funds, and really a duty to preserve the integrity of the trust property. If we had more time today, we would get into all of the differing fee agreements that exist. Just briefly, the classic or the general retainer. I think this is a little bit anachronistic. That used to be where you were, paying the lawyer a fee to secure their availability. Security or advanced retainers, those are earned when you actually perform the services. Contingency fees, flat fees, again, wide distribution or wide variation on what those are and the requirements of them from state to state. When you're making this decision, though, just some things you want to consider, what is in the best interest of the client, right? You're going to look at the facts and circumstances of each case, the reasonableness, the structure, how the fees are going to be divided, and then consider what is my best vehicle. Lastly, before we end here, what must go into the client trust fund account? It is nominal or short-term funds that belong to a client or third party, unearned legal fees and costs, and funds, where there may be a disputed funds. What doesn't go in there? Earned fees, those come out right away. And, except for those funds, to cover bank fees. Pooled accounts, it's just that, right? You can contain the monies of several clients. It can be interest and dividend bearing. Nominal amounts only held for a short period of time. And then the interest on that goes to lawyers' trust funds or public trusts rather than going back to the client. Now, if you have an opportunity where a client may actually gain some interest on a settlement or monies that you are holding, and it's a large amount and it's going to be held for a long period of time, then you can have a separate client trust fund account for that one, and the interest will go to that specific client. What questions are you going to ask yourself when you're making that determination? Well, the first one is, are the funds nominal, or are they expected to be held for a short period of time, right? That's going to be into a pooled account. Or is it going to be held for a longer time and it's a larger amount? Can this client actually get the benefit of some interest that is going to be accrued on this money if I'm holding it for a longer period of time? Certain things with regard to other property, if you're accepting things instead of cash, right? What you're supposed to do there. It still has to be separate, still has to be identifiable, still has to be labeled. Placing it in a safe deposit box, not in your office drawer. A few good practice tips here for you when you're managing your IOLTA or your client trust fund account. Even though you may have somebody else doing it, I think vetting of that individual or individuals, and it doesn't really, negate your obligation under Rule 1.5 to reconcile, to review, to make sure that that account is as it is supposed to be. And then with this regard to disputed funds, if there's a dispute over, certain amount of funds, you can't engage in self-help, right? You don't get to just take that for your own. You leave it in the trust account until that dispute is resolved. If the dispute can't be resolved or you don't want to hang on to it anymore, certainly filing an interpleader with the court and letting the court decide what's going to happen to that is important. 1.16D talks about, look, when the representation is over, when it's terminated, any fees that I haven't yet earned have to be returned to the client. Let's see. With that, I think I am out of time. So I will turn it back to Nina for any questions that we may have. I'm happy to stay around and answer them.
Now, as Tracy mentioned, we can go ahead and move on to questions. Looks like we've got a few. So our first question is, how can I ensure my fee agreements are both ethical and enforceable?
My goodness. Question. I would love to give my lawyer answer and say, well, it depends, but I'm going to be a little bit more descriptive than that. I think when you talk about ethical and enforceable, sometimes those two, they go together, right? Not always, but they go together. Certainly, the first thing you have to consider is the 1.5A reasonableness standards, that shopping list, those 8 things. You really have to look at and compare all of it. I mean, not every one of those is going to be relevant, but you really do have to look at that. And then some of those other factors where courts have made fee agreements be unenforceable or unethical, are some of those things that I described, improper referral relationships, bill padding, not doing enough, doing too little, doing too much. It really is, sadly, going to be a facts and circumstances based equation. And I will say, you talked about ethical, you talked about enforceable. In some respects, one thing that you also want to consider is, I got to get paid, right? And part of you want to get paid, right? And part of the getting paid is, as I've talked about, establishing this ongoing discussion about the money throughout the course of the representation. It really does, in my line of work and in my experience, it really does help you in the end. The client pays those bills, whatever you have to do to make it feasible. So attorneys get to get paid. Unless you started doing this on a pro bono basis, you should be paid for the value of your services. And doing all these things, as I've discussed, will help you get there.
Awesome. Thank you, Tracy. Our next question is, what are the best practices for someone like myself who does commercial litigation in the Northeast? I have a multi-jurisdictional practice with trust accounts for each state, clients that live and do work in different jurisdictions, and there's often a choice of law and venue questions that come up. How would you handle that?
Well, you know, part of my first statement would be you really have to know what the 1.15a rules as well as 1.5a rules are in your jurisdiction. What I will send you to is a great, great, great website that is maintained by the American Bar Association. And if I had it here, I would put it in the chat, or you can contact me offline later and I'll give it to you. What it is a rule comparison chart. It is what the model rule is and then what the rule is in each state. So you don't have to go hunting all around, particularly if you're doing multi-state practice. You can see what they are, where they are. The other thing is, and you're getting into when you talk about fee agreements and you're talking about enforceability, you have to think about sort of 8.5 issues, choice of law issues, where is the client, where is the cause of action, in what jurisdiction, in what state, and that comes into play too, because when you're thinking about what type of agreement you're going to set up, whether it's going to be a fixed fee, flat fee, advanced payment fee, you have to know what the state's rules are around that and what the requirements are. So I think the best thing that I can say is look to see where, going back to like international, your civil procedure days, right? International issue, minimum contacts. Think about where you are, where the parties are, where the issue is, and then go from there.
Awesome. Thank you for those tips. We have time for a couple more questions. So the next one is, if a client disputes my final invoice, how can I ethically resolve that issue while still complying with my fiduciary duties?
Yeah. That's always that's the trick, right? And there's a great case. I don't know where this person is, but there's a great case out of DC. It's called Inri Har, and HAAR, and it's a case that really talks about self-help, right? Where, hey, I think I've earned it, and it's in a retainer, and I'm just going to take it, or where there's a dispute over, let's just say that's where I've taken a retainer and the money's sitting there and I just take it for myself. You can't do that, right? That you have to keep the amount that's in dispute in your IOLTA, in your trust fund account until that dispute has been resolved, either by you and the client or as an interpleader. Now, the other situation is I send an invoice and my client says, yeah, you know what? I really don't think you earned that, or I don't want to pay that, or I really don't think the value of what you provided equals that. I mean, it's a problem, and it happens. And there are a lot of client disputes for whatever reason. Sometimes it doesn't even come from they're disputing the money or what you charged. There's just a loss of trust or a breach in the relationship. And, in some respects, this is a contract, right? Your client entered into it. They agreed to it. Certainly, as I said, you can try some of those communication or negotiation or compromise ideas that I talked about. And if they're not going to pay and you earned and you can justify what you earned, your options are collection suit or I let it go. And that's a tough that's a tough decision to make. But I think communication is key, as well as determining or doing your due diligence on the client's financial wherewithal to pay these fees. And again, because if they don't have the money up front and it, they're never going to pay the fee on the back end. You just have to say, right client, right amount of money, all those kinds of questions at the beginning.
Tracy. Our last question for today is, what steps should I take to ensure I properly return client funds and property upon termination of representation, if that occurs?
I will take the financial part because we could have a whole discussion on return of client files and those kinds of issues. I'm going to talk about the money parts, as we're talking about money and it's tax day. When the representation is terminated or you withdraw and you have taken an upfront retainer, but you haven't earned it all, right? And that money is sitting in your client trust fund account, and you've been billing down against it as you've been going forward. Or in some cases, I'm not going to get into fixed fee or, that's a whole nother can of worms, but let's just talk about the billing down from. And I get to the point where a client fires me or I just don't want to represent this client anymore. I mean, that's when you go through your bills, where you go through what's been paid, what services you provided, and you say, look, here is what you owe me from this. Hopefully they will agree. And then the rest is just refunded. The part that I have not earned is refunded to the client. It's kind of like basic bookkeeping, but the issue there is whether the client actually agrees in the end, especially if it's been an acrimonious withdrawal or termination.
Awesome. Well, thank you so much, Tracy, for all of your insights. And thank you all for submitting your questions. We want to thank you for joining us for another Justia webinar. As we mentioned earlier, don't forget to take advantage of a powerful free law resource that's available to Justia Connect members, the Justia Daily Opinion Summaries. You can get next day alerts with concise summaries of the latest court opinions for the jurisdictions and practice areas that matter most to you. Stay informed and stay ahead. Sign up now at newsletters.justia.com and never miss a key legal development again. And have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.